Welcome to the Penn State Center for Agricultural and Shale Law's YouTube channel. In this short video, I would like to introduce you to the Renewable Fuel Standard. My name is Chloe Murray, and I'm a researcher at the center. The Renewable Fuel Standard, or RFS, is a federal market-based program for which the objective is to increase nationwide the use of biofuels in transportation fuels. The RFS program requires a mandatory blending of a certain volume of biofuels in gasoline and diesel sold in the United States. The goal is to use at least 36 billion gallons of biofuels by 2022 to reduce greenhouse gas emissions from the transportation industry. The Renewable Fuel Standard program was established by the Energy Policy Act of 2005. And later expanded in the Energy Independence and Security Act of 2007. The law imposes a statutory volume of renewable fuels that must be blended into gasoline and diesel each year. The U.S. Environmental Protection Agency is the agency responsible for overseeing and administering the Renewable Fuel Standard program, including evaluating which renewable fuels are eligible for the RFS program, but also translating volume targets set out in the law into volume obligations that will apply to fuel refiners and blenders. EPA, however, has some discretion to change and reduce the volume obligations. This is called a general waiver. The law provides EPA with a general waiver authority, allowing the agency to reduce the RFS volume obligations for renewable fuels. EPA may decide whether to reduce partially or completely the RFS volume obligations in situations where implementing those obligations would damage the economy or environment of a state, region, or the nation, or where domestic renewable fuel supply is considered insufficient for fuel refiners and importers to meet the volume requirements. Fuel refiners and importers may also file a waiver request with EPA, following which EPA has 90 days to approve or deny it. Fuel refiners and importers have an annual renewable volume obligation to comply with the RFS statutory volumes, and EPA is responsible for monitoring and enforcing compliance with these obligations. To enforce the renewable volume obligation, EPA uses a tradable credit system to record compliance, called Renewable Identification Numbers. When qualifying biofuels under the program are produced or imported, each gallon is assigned a renewable identification number. It is a unique 38-character number. Every year, fuel refiners and importers must multiply the RFS volume requirements by their total gasoline and diesel sales to calculate their renewable volume obligations. The volume obligations correspond to the total number of each identification number the suppliers must submit to EPA. If fuel refiners and importers cannot comply with their volume obligations, they are allowed to purchase renewable identification numbers. Purchasing renewable identification numbers, however, can be expensive, especially for small refineries. That is why Congress enacted a small refinery exemption. The law provides for a small refinery exemption, where it exempts small refineries from complying with their volume obligations if compliance would subject them to disproportionate economic hardship. The statute defines a small refinery as a refinery for which the average aggregate crude oil production does not exceed 75,000 barrels per day. A small refinery could petition EPA to receive an exemption until 2011, provided it could demonstrate disproportionate economic hardship. EPA, together with the U.S. Department of Energy, is responsible for determining whether a small refinery may suffer from disproportionate economic hardship due to its renewable volume obligations compliance. The statute, however, does not expressly define the terms disproportionate economic hardship, and to make that determination, the U.S. Department of Energy would evaluate if complying with the volume obligations would result in a high cost of compliance related to the industry average, as well as an effect sufficient to cause a significant impairment of the refinery operations. The statute provides small refineries with the possibility of requesting an extension of a hardship exemption at any time. The US Supreme Court recently interpreted this provision as meaning that a small refinery, which previously received an exemption, may still receive an extension even if it did not acquire a continuous extension in previous years, thus allowing a previous exemption to lapse. More resources can be found on our website at aglaw.psu.edu, where we regularly post new work products.